My name is Sam S. Stryker. Despite my youthful appearance, I've been teaching here since 1979, with 1 or 2 years off. I am, among other things, the faculty director of the Institute of Judicial Administration, which is one of the oldest organizations here at the law school. It was one of the brainchilds of Arthur Vanderbilt. This building is named after Arthur Vanderbilt. He was considered the legendary dean of the NYU School of Law until John Sexton and his successors came over. But he had a number of ideas, one of which was IJA, which was basically the law school's liaison with the judiciary. And so we have a number of programs, a number of initiatives, and one of the things we do is run the Brennan Lecture for State Courts and Social Justice. This picks up on a theme of Justice Brennan, that the state courts can construe their own constitutions differently than federal constitutions. And we thought it was fitting to name the lectureship after him. I don't know which year we're in, but we've had it's an unbelievably lustrous list of people that have been Brennan lecturers. John Lippman, of course, is here. I'm going to end up not missing some people here, but it's really remarkable. And typically these are lectures by state judges. This is a state judge program. The state judges are, in fact, the principal, in my view, the principal agent for justice and rights here in the United States, because they carry most of the decisional weight of the country. Federal courts get a lot of resources, they get some publicity, but the federal courts have limited jurisdiction. The states have plenary jurisdiction, so we're very pleased to recognize the state courts, and in our programs we have ample representation of state judges. Wallace Jefferson, I don't think is in the audience, but he was a Brennan lecturer, is he? I don't think so. And he's now he's going to be the new president of the ALI, the American Law Institute. Janet DeFiore was a Brennan lecturer, as was George Bundy Smith. I don't know if they're in the audience. We thought they might be. There's been a drop-off in the attendance, a pretty good attendance, by the way, but there's been a drop-off because of the storm, or the effects of the storm, or the fear of the storm, whatever. It's my pleasure to introduce Evan Chesler. Evan is a mainstay of New York University, not just the law school. He had an undergraduate degree from NYU and had an uptown campus. I don't know if you folks remember that, a very beautiful uptown campus. And he went to the uptown campus, yes. And he's also a graduate of our law school. He's the head of the NYU trustees, NYU Law School trustees, and NYU University trustees. And he's a full-time mediator and arbitrator now. He's essentially retired from Cravath, where they created a position for Evan. Is it chairman? Chairman of the firm. And he is so fantastic an occupant of that position that the law firm has not decided yet whether to have a successor for him, because they fear instant failure if they can't meet the standard. Evan Chesler introducing our guest.
Thank you, Sam, I think. For those of you who have any spare time, I'd recommend becoming friendly with the Chief Judge, because he gets asked to speak a lot and you might be elected to the introduction club. You're good to him. I've known the Chief Judge for 40 years. In the fall of 1986, I was a young partner at the Cravath firm, and I was getting ready to try a large, complicated antitrust case. I was terrified. And the then head of our litigation department, who was a great trial lawyer named Tom Barr, called me and said, I know you don't have enough people, you're working very hard, you need help. There's this young guy who's just arrived from a clerkship in the Ninth Circuit, and I'm going to send him over to help you. And I said, tell me a little bit about him. And he gave me the normal credentials, Harvard College and Harvard Law School. He clerked on the Ninth Circuit. He said, but the most important thing about him is he's an old soul. Now, unfortunately, I'm sure most of you didn't know Tom Barr. He was a great trial lawyer, a great person. But to him, calling someone who was then about 25 or 26 years old an old soul was a profound compliment. What I learned over the years, Rowan worked for me for a while. We worked together. We were partners for 25 years. We became very good friends. We tried cases together. For those of you who are trial lawyers in the room, you know that that's about as close to a professional marriage as you can get, with all of its positives and negatives. He is whip smart. He was, from the moment I met him, obviously a naturally talented lawyer. Perhaps most importantly, other than my mother of blessed memory, he probably is the nicest person I have ever known. And he's funny. So I have one quick story on this last point. Some years ago, the chief judge and I were preparing to try another antitrust case in the Eastern District of Pennsylvania. And we were doing one of the less glamorous things that trial lawyers do. We were reviewing the ITEs, the intended trial exhibits that the plaintiffs had dumped on us. And we were locked in a conference room for days with boxes of these documents, looking at the proposed objections that the associates on the team had written out, deciding whether we were going to press the objections or abandon the objections. And we had boxes and boxes of these documents which we were crawling through. And there was a young associate on the case who was, I guess I should say, more enthusiastic than able. And he spent most of his time desperately trying to demonstrate to Rowan and to me how smart he was. And so at some point in the midst of this drudgery that we were going through in reviewing the ITEs, the door to the conference room burst open as if it had been blown off of its hinges. And this young man bounded into the room and with great enthusiasm said, "I've got it. I've got it. I figured out exactly how we're going to win this case. I've got it." And Rowan, being as polite as he always is, said, well, tell us about that. And this young fellow then launched into a soliloquy. And about 2 minutes into it, I'm sitting there thinking, maybe he really is very smart and I just can't understand him. But I've not understood a single word he said after I got it. And I looked over at Rowan, who was totally poker-faced. I mean, no smile, no frown, no nodding of the head, nothing. He was awake, but showing no emotion whatsoever. And I'm thinking, maybe both of these guys are a lot smarter than me. And Rowan very discreetly writes something on a yellow legal pad and quietly just slides the pad over to me. And I look down on the pad, and there's one word written on the pad: Yale. Ladies and gentlemen, the Chief Judge of the State of New York, the Honorable Rowan Wilson.
Yep, that happened. So thank you, everyone, for being here. It's daunting enough to be asked to deliver the Brennan Lecture, and doing so on the 30th anniversary is especially so. And I should say that, all I really had was sort of a rough idea, and the people who are really responsible for the research and for a lot of the words you're going to hear today are my 3 law clerks, 2 of whom are from Yale. Times change. So Chief Judge Judith Kaye began the inaugural lecture 30 years ago by noting that among Justice Brennan's greatest achievements was teaching us that the basic elements of our humanity, dignity, empathy, and passion cannot be strangers to judicial decision-making, that the most rigorous, most admirable legal thinking is guided not only by the head, but by the heart. 20 years before that inaugural lecture, as you heard from Professor Sakharov, Justice Brennan issued a call to action to state high courts. As the power of the federal government had inconceivably broadened over the course of his lifetime, Justice Brennan worried that the United States Supreme Court had retreated from giving full effect to the Bill of Rights and the 14th Amendment, the core safeguards against, in his words, arbitrary action by governments more powerful and more pervasive than any in our ancestors' time. He beckoned state high courts to step into the breach by construing their state constitutions independently of the Supreme Court. He continued, "The genius of our Constitution resides not in any static meaning that it had in a world that is dead and gone, but in adaptability of its great principles to cope with the problems of a developing America." That work of adaptation requires the courts to breathe life into constitutions, both federal and state. In Chief Judge Kaye's lecture, she observed that state courts across the country had begun to expand their own constitutional protections beyond those offered by the federal Constitution, although in decisions exposing close, heated divisions, unusual in the jurisprudence of those courts. On occasion, those decisions set an example for the Supreme Court to follow in its interpretation of the federal Constitution. Chief Judge Kaye then offered a crucial insight. Because state courts are literally and figuratively closest to the people, and because state courts, unlike federal courts, have the capacity to shape the common law, they are especially suited to the task of adapting law to meet modern problems. In the age of statutes that often fail to capture the complex interplay between human facts and abstract laws, Chief Judge Kaye explained that state courts can lean on their unique common law powers to be courageous legal innovators, taking comfort in the fact that common law decisions can be corrected by statute. Put simply, she believed that the open dialogue between state legislatures and state judiciaries means that state court judges should feel no compunction about crafting the common law to meet modern problems. Indeed, given that state courts are often the first to confront the newest, most vexing gaps between our legal ideals and hard realities, innovation is precisely what the people expect us to do. She concluded by offering that she would be delighted if her comments about the unique tradition, competence, and the role of state courts stimulated others to focus attention on our state courts and state lawmaking. Whereas Chief Judge Kaye's focus was on the common law, mine is on state constitutional law. I propose to you that the insights she raised apply with comparable force, although for somewhat different reasons, to the interpretation of state constitutions. For just as state courts are closest to the people in the senses she identified, they are also close to the people in a constitutional sense. A common feature of state constitutions is that they are more readily amendable than their federal counterpart, such that constitutional decisions by state courts are, relative to the federal constitutional decisions, more readily revisable by state legislatures or the people. Just as Chief Judge Kaye believed state courts' proximity to the people should encourage them to innovate boldly in the arena of common law, that proximity should inspire a similar courage to innovate in the constitutional arena, similar in kind if not in degree. Specifically, when compared to the present-day federal constitutional adjudicative principles, state high courts should feel at greater liberty to depart from rigid adherence to stare decisis when interpreting a state constitution, because those constitutions are more readily amendable and more directly shapeable by the people and their representatives. The possibility of dialogue via the amendment process between the people and their state high courts, something the U.S. Supreme Court lacks, endows state courts with a backup, empowering them to render innovative decisions without eroding judicial legitimacy. Correspondingly, state legislatures and citizens should feel more comfortable amending state constitutions to encompass new positive rights to be fleshed out by state courts, because those interpretive decisions can be altered by future amendments. To understand how the amendability of a constitution should inform principles around judicial interpretation, I begin with a brief examination of the first written constitutions. The written constitution, a single document that sets forth the organizational principles of a government in a form different from and superior to statute, is an American invention. The American colonists, influenced by the Roman Republic's detailed codification of laws, but also by the Enlightenment philosophers and political theorists who rested governmental legitimacy on variations of an implied contract justification, set out to establish the structure of government in a written form akin to a contract. The first 4 colonies to create written constitutions did so before the Declaration of Independence was signed, and the first 3 did not call them constitutions. The first was New Hampshire in January of 1776. That constitution contained no statement of rights. It merely established the composition of the government and certain features of its operation. For example, it provided that all bills to raise revenue must originate in the House of Representatives, no acts would be valid unless passed by both legislative houses, and the 2 houses could not adjourn for more than from Saturday to Monday unless both houses agreed. In March 1776, South Carolina created a document setting forth the structure of its new government. Like New Hampshire before it, South Carolina set out the structure of its government without any enumeration of individual rights. But in June 1776, Virginia adopted 2 documents, a Declaration of Rights and a Future Form of Government of Virginia. The Virginia Declaration of Rights, which strongly influenced the Bill of Rights, articulated some rights as positive rights held by individuals, for example, all men have the right of suffrage, and some as restrictions on the power of government, for example, general warrants ought not to be granted. On July 2, 1776, New Jersey adopted an integrated document which it called a constitution, containing both a set of positively stated individual rights and restrictions on governmental authority, as well as portions setting out the structure of its new government. New York followed suit in April 1777. New Jersey was the first constitution specifically to adopt the common law of England, allowing that it could be changed legislatively. New York's, Delaware's, and Maryland's subsequent constitutions did the same. Other states imported English common law via reception statutes, which deemed English law as of a certain date to be integrated into the state's laws. Some of the rights expressly guaranteed in those first constitutions were even expressed as common law rights that, because of their natural law origins, could not be abridged, even legislatively. These colonial constitutions form an important background leading up to the U.S. Constitution. They reflect the revolutionary sensibility, forcefully stated in the Declaration of Independence, that certain rights were natural and inalienable. The colonial constitutions were principally devoted to establishing governmental structure. They isolated a few actions as beyond even governmental incursion and otherwise left the common law in place, allowing both the legislative and judicial branches the power to alter the law, subject to the restraints placed by natural law. When initially adopted, both the various state constitutions and the federal constitution were expected to be amendable. As the 1776 Virginia Constitution announced, all people have certain inherent rights of which, when they enter into a state of society, they cannot, by any compact, derive or divest their posterity. All power is vested in and consequently derived from the people, that magistrates are their trustees and servants and at all times amenable to them. The 1784 New Hampshire Constitution went the furthest, stating that when the Constitution fails to work for the common good, the people may, and of right ought to reform the old or establish a new government. And the Declaration of Independence itself rests on the premise that people have an inalienable right to cast off an existing government and form a new one. Now, because it has become virtually impossible to amend the United States Constitution, the decisions of the United States Supreme Court have become the exclusive source of constitutional change. But the founders envisaged a more popular and more lively culture of amendment. Their vision was one whereby the U.S. Constitution was not only more amendable by the people, but also mostly concerned with establishing the structure of the government and delineating its powers, leaving the articulation of the protection of individual rights against legislative incursion to the courts via the common law, which incorporated a natural right element. Understanding why that vision has not borne out helps to clarify why I believe state courts should be more innovative in their constitutional decision-making than their federal counterparts are now. What was the founders' original vision? For starters, they wanted a document that was mutable. When drafting the Constitution, they had learned from the practical immutability of the Articles of Confederation, which required unanimous consent of all 13 states to make any amendments. Recognizing the unworkability of a Constitution that proved impossible to change, the founders eschewed it in favor of one that balanced an extreme facility which would render the Constitution too mutable against that extreme difficulty of amendment which might perpetuate its discovered faults. Madison emphasized that the states would be a crucial source of constitutional innovation. He thought a strength of the new Constitution was that it equally enables the state governments to originate the amendment of errors as they may be pointed out by the experience on one side or the other. In addition to creating an amendable Constitution readily able to meet future challenges, the founders also preferred to leave individual rights largely unarticulated. The original draft of the Constitution did not contain a Bill of Rights, following an example of states like New York, whose constitutions were basically dedicated to setting out the structure of government rather than enumerating fundamental rights. In the Federalist Papers, Madison specifically praised New York's 1777 Constitution for its lack of a Bill of Rights. Georgia, New Jersey, and South Carolina also chose not to affix a Bill of Rights to their original constitutions. Even in Virginia, which had a Declaration of Rights drafted by George Mason, that document was separate from the state constitution. Because of the prevailing notion that people possessed certain inalienable natural rights, some feared that enumerating rights might imply that all others were excluded. Additionally, because of the Bill of Rights operated against only the federal government, it was assumed at the time that states themselves would enforce fundamental rights. Thus, the founders held both a dynamic vision of popular constitutional amendment and a more pronounced role for states in defining the rights that enjoyed the highest level of protection. Both state and federal courts would play important roles in articulating those rights, and if they erred, the federal and state constitutions provided many different routes to enacting formal constitutional amendments. The earliest amendments after the Bill of Rights illustrate the dynamic process of amendment the founders imagined. When the Supreme Court held in 1793 in Chisholm v. Georgia that Article III granted federal courts jurisdiction over disputes between a state and an individual of another state, the states were outraged. 2 years later, in 1795, in a remarkably swift amendment process, the 11th Amendment was ratified to overturn that decision. Then, when the electoral crisis of 1800 revealed a blind spot to the founders that they didn't anticipate the rise of political parties that could splinter a presidential ticket, it took only 4 years to ratify the 12th Amendment, which required electors to cast separate ballots for president and vice president. On both occasions, the founding generation proved ready and eager to change the Constitution according to the needs of the nation. Over time, however, partisanship fractured national politics in a way that has rendered constitutional consensus extremely hard to attain. After the 12th Amendment, it would be 60 years before the next federal constitutional amendments came as a result of the Civil War. The Reconstruction Amendments were adopted only because they were a required condition of re-entry of the Confederate States, then controlled by Reconstruction governments, into the Union. It would be 43 years after those amendments before the next one, which constitutionalized the federal income tax, was passed. Save for the 19th and 26th Amendments granting women and 18 to 20-year-olds the right to vote, the post-Reconstruction amendments concerned the operation of the federal government, not individual rights. Even the 19th and 26th Amendments did not create new rights, but merely extended voting rights to a broader group of American citizens. Although the formal amendment process has broken down over time, the country's need for constitutional change has not abated. As Chief Judge Kay observed 30 years ago, the inevitable gap between the limited foresight of law and the reality of experience will always call out for revision. In her words, so long as human language remains imprecise and the human capacity to predict the future limited, the cascade of cases that call upon judges to fill the gaps will unquestionably continue. Over time, as the federal constitutional amendment process became unusable except for minor changes about the operation of government, such as the 2-term limit on the presidency or rules about presidential disability and succession, the pressure for change has become increasingly channeled through the Supreme Court. As Justice Brandeis observed, in cases involving the federal Constitution, where correction through legislative action is practically impossible, this court has often overruled its earlier decisions. By the middle of the 20th century, the U.S. Supreme Court emerged as the primary locus of federal constitutional change concerning individual rights. Landmark decisions like Brown, Gideon, Mapp v. Ohio, and Baker v. Carr were comparable in significance to constitutional amendments, bypassing the practically unavailable formal amendment process. For a time, that development appeared to offer a functional substitute by which the living promise of the Constitution could be carried into modern times. However, a government that makes its highest court the exclusive source of constitutional change is precarious. The system of government, both state and federal, rests on political legitimacy, not on the divine right or brute force, but on popular consent and trust. When the practical expositions of the highest principles are arrogated to one branch of government and protractedly unresponsive to popular will, the fundamental precept on which our governments are based falters. That is especially true when that branch is the least democratic of the three. The founders' vision was inherently a dialogic one. Courts would decide cases that resolved specific articulations of a constitutional principle, and the people could respond through a dynamic process of constitutional change. That's what happened with the 11th Amendment. But once the avenue for formal constitutional amendment closed, the Supreme Court was left isolated, without any democratic interlocutor to respond to or correct its constitutional decisions. The court had to rely on itself and its adherence to its prior decisions, that venerable principle of stare decisis, as the main source of legitimacy. So as the U.S. Supreme Court has increasingly reversed many of its landmark constitutional decisions with hastening pace in recent years, it has sawed away at the main branch upon which its legitimacy rests. State courts do not labor under the same lonesome burden as the United States Supreme Court. Simple reason for the difference is that we have an active interlocutor in our decision-making process, the people. With state constitutions that can be and are regularly amended through avenues such as the popular referendum or constitutional convention, state courts operate with a reliable democratic backstop when performing the work of constitutional adjudication. Justice Robert Jackson once famously said of the Supreme Court, "We are not final because we are infallible, but we are infallible only because we are final." Yet state courts can act with the courage to be sometimes fallible, because their decisions are final only when the people allow them to be. That makes all the difference. New York has had a vibrant history of amending its constitution. Since the original Constitution of 1777, New York State has held 8 constitutional conventions, 3 of which overhauled the entire Constitution. Since 1894, the most recent overhaul, the New York Constitution has been amended over 200 times. The volume of state amendments is magnitudes greater than amendments to the federal Constitution. Out of over 12,000 proposed amendments to the federal Constitution, only 27 federal amendments have ever been ratified. New York's experience is common to many other states. New Hampshire has had 17 constitutional conventions, and its constitution has been amended nearly 150 times. Massachusetts has had 4 constitutional conventions, and its constitution has been amended more than 120 times. Alabama has had 7 constitutions, resulting from 6 constitutional conventions, and its 1901 Constitution has been amended more than 1,000 times. That does seem a bit much. As with most other state constitutions, the New York Constitution can be amended by direct popular consent. Before a proposed constitutional amendment is adopted, New Yorkers must ratify it by a majority vote. There are 2 avenues by which amendments make it on the ballot, either by majority vote of the legislature in 2 subsequent legislative sessions, or by a constitutional convention. In fact, our Constitution was amended during the 1846 convention to require the state to place on the ballot for popular consideration every 20 years whether to hold a constitutional convention. The relative ease with which New Yorkers can amend the state constitution is evidence of the popular expectation that it is meant to accommodate change. 18 states go even further by incorporating an explicit constitutional guarantee of the people's right to amend their constitutions by proposing and ratifying amendments directly. Despite recent attacks on the people's right to amend, amendments, conventions, or even wholesale constitution revision does not mean political instability or the end of democracy. Rather, the dynamic relationship between our state's constitution and its people promotes a healthy system of governance. To illustrate my point, I offer 3 examples of when New Yorkers used the constitutional amendment process to enact significant changes that would, at least today, be unimaginable in the federal context. The first example is Article 17 of the New York Constitution. New York, as is true in many other states, confers a host of positive constitutional rights, which are virtually absent from the federal Constitution. Perhaps the most notable panoply of positive rights was born out of the Convention of 1938, which New Yorkers voted to hold. The convention redefined government's relationship to New Yorkers and committed the state to a new set of social responsibilities involving labor, health, welfare, and housing. The historical concept is important to understand the impetus for such a sea change. The Great Depression forced countless New Yorkers out of their jobs and homes, straining local relief mechanisms. In response, convention delegates proposed, and the people with overwhelming support approved, a bundle of amendments, including Article 17, also known as the Social Welfare Article. That article is one of a kind. Section 1 mandates that the aid, care, and support of the needy are public concerns and shall be provided by the state. The Court of Appeals has held that Section 1 unequivocally prevents the legislature from simply refusing to aid those whom it has classified as needy, adding that such a definite constitutional mandate cannot be ignored or easily evaded in either its letter or its spirit. The effects of the article cannot be understated. For example, through litigation asserting rights under the Social Welfare Article, unhoused people in New York City have a legal right to shelter. By contrast, the U.S. Supreme Court has explicitly declined to find a right to welfare in the federal Constitution. Convention President and former Chief Judge of the New York Court of Appeals, Frederick E. Crane, aptly synthesized the ethos animating the Convention of 1938. We are here to do one thing, if nothing else, to prove to the world that our form of government does work. As the Social Welfare Article illustrates, the amendment process opens up the door for New Yorkers to shape their relationship with government. It also provides an avenue by which New Yorkers can directly respond to and correct state and even some federal judicial decision-making. The referendum process for amendments provides effective popular response to address important social needs when the judicial system fails to act or fails to act in accord with such needs. The second example of a significant change effected through New York's constitutional amendment process is New York's workers' compensation scheme. In 1910, the New York legislature passed the first workers' compensation law, the first comprehensive scheme of its kind in the nation. However, the Court of Appeals deemed the law unconstitutional, holding that the statute failed to preserve employers' due process of law because it authorized the taking of the employer's property without his consent and without his fault. The court handed down its decision on March 24, 1911. The very next day, a fire broke out at the Triangle Shirtwaist Company. 146 people, mostly women and girls, died. The fire spurred such fierce opposition to the court's invalidation of the workers' compensation law that 2 years later, in 1913, the people passed a constitutional amendment explicitly authorizing the legislature to reenact the scheme, overriding any other conflicting provision of the Constitution. The legislature did so the following year. Because of the forceful language in that constitutional provision, subsequent constitutional challenges to the workers' compensation law have largely failed. New Yorkers are not just attuned to decisions from our high court. My third example shows how New Yorkers use the state amendment process to expand state constitutional protections when the U.S. Supreme Court declined to do so. In Olmstead versus United States, the Supreme Court held that warrantless wiretapping was lawful under the Fourth Amendment, provided that the taps were installed outside of a person's home. That's the best place to install them anyway. 10 years later, delegates to the 1938 New York Constitutional Convention proposed and voters ratified a constitutional amendment that incorporated an express prohibition regardless of wiretapping, regardless of where the taps are placed. At the convention, Governor Lehman emphasized the need to protect scrupulously against wiretapping, quoting Justice Brandeis's dissent in Olmstead. Writs of assistance and general warrants are but puny instruments of tyranny and oppression when compared to wiretapping. Now, the federal Constitution prohibits warrantless wiretapping, but not through constitutional amendment. Instead, nearly 40 years after New Yorkers amended our Constitution, the Supreme Court overruled Olmstead. The workers' compensation and Olmstead examples make clear that when the constitutional amendment process is functionally accessible to the people, judicial intervention is not necessary to resolve erroneous or outdated interpretations of law. Conversely, where the amendment process is practically unavailable, a polity is forced to rely exclusively on judicial modifications and reversals. The varied sources of constitutional change in New York have generated a healthy, active adaptability that strikes a balance between stability and innovation. Of course, the New York Court of Appeals has historically exercised an important role in the development of our constitutional jurisprudence, but the court is not the sole arbiter of constitutional change. The people, either directly or through legislative propounded referenda, have regularly and consistently amended our Constitution. Such a robust dialogue between the branches of government and the people makes for greater governmental legitimacy quite apart from stare decisis, and it depends, ultimately, in the final word resting with the people, not any single branch of government. State high courts are constantly presented with and have an obligation to decide important constitutional disputes. This past year alone, the Court of Appeals decided whether allowing non-citizens to vote in municipal elections violated the state constitution, whether the even-year election law violated the New York or federal constitutions, whether a defendant's conviction by an 11-member jury violated the constitutional right to a jury of 12 people, and whether the Foreclosure, Abuse, and Prevention Act's retroactive application violated the right to due process under the New York State Constitution. Whether our decisions in those cases will become ingrained in state law or a relic of history is ultimately a decision for the people. At Chief Judge Kaye's inaugural lecture, she celebrated state courts' use of the common law because common law decisions, unlike constitutional ones, are more susceptible to subsequent modification. Relying on the common law enables state courts to shape evolving legal standards more cautiously, and thus allows them some flexibility that is not an option for federal courts. Today, I make that same extension to state court decisions grounded in their respective constitutions. Viewed on a continuum, state constitutional interpretation may not and should not be as freely altered as state common law or statutory interpretation, but it is certainly more easily reformed than federal constitutional interpretation. It is the impermanence of state constitutional decisions that reveals their value. Historically, the New York State Court of Appeals construed provisions of our Constitution as distinct from contracts and statutes because it believed the approval of the people of the state gives force to a provision of the Constitution drafted by the Convention, and in construing the Constitution, we seek the meaning which the words would convey to an intelligent, careful voter. However, in 1980, we overturned that approach in favor of a more realistic approach that interprets the Constitution by applying the traditionally accepted standards of statutory construction. That shift by our court to treat constitutional and statutory interpretation similarly, unlike federal courts, who employ a sort of constitutional exceptionalism, illustrates that because a state constitution is amendable, it is not so fantastically exceptional after all. It is this perception of a state's constitution as a mutable living document that gives state court judges more space to interpret their constitutions flexibly, promoting genuine inquiry into what a state constitution should mean today without an originalist focus trained on what the drafters may have intended to mean eons ago. The case studies of constitutional change already discussed, the Social Welfare Act, the workers' compensation laws, and the legality of wiretapping, demonstrate our state system working as the framers intended its federal counterpart should. But just as those instances should encourage state courts to continue to push boundaries in constitutional interpretation, knowing that if they get it wrong, a state is not bound to that failure, we also see that if the courts get it right, their interpretations can endure, shaping the rights of the state's constituents well into the future. The constitutional dialogue between courts and the people facilitated by the amendment process is important for another reason. It encourages the people, when amending the Constitution, to grant new rights broadly stated, leaving it to the courts to take the first bites at thereafter operationalizing the meaning of those amendments. Since Reconstruction, no federal amendment has embodied a new affirmative right. Meanwhile, state constitutions, including New York's, have regularly been amended to add such rights, often in broad terms that require judicial refinement. But with state constitutions, judicial decisions misapplying those rights can be overruled or adjusted by the people. This too helps facilitate trust in government. For example, in 1894, as part of one of the complete constitutional overhauls, the Education Article, now Article 11, Section 1, was added to the New York State Constitution. The Education Article states, "The legislature shall provide for the maintenance and support of a system of free common schools wherein all the children of the state may be educated." The Court of Appeals has interpreted that provision as requiring the state to offer a sound basic education to all school children. With that interpretation, the Court of Appeals reshaped the state's education system and created a positive right that affords students with the opportunity for a meaningful school education, one which prepares them to function productively as civic participants and compete for jobs that enable them to support themselves. The positive right to a sound basic education exemplifies an interpretation by the Court of Appeals that is now deep-rooted within the state. We can be fairly certain that the failure to amend the sound basic education doctrine reflects the people's century-long satisfaction with the court's interpretation. Similarly, the New York State courts have interpreted our Constitution to include a right to counsel that, as compared to the U.S. Supreme Court's interpretation of the analogous federal right, is both broader and firmer. The New York Constitution's Bill of Rights provides that in any trial in any court whatever, the party accused shall be allowed to appear and defend in person and with counsel as in civil actions. That language, alongside the state constitution's due process protections and the privilege against self-incrimination, led the Court of Appeals to express its special solicitude for the fundamental right to counsel, because the presence of an attorney is the most effective means we have of minimizing the disadvantage at which an accused is placed when he is directly confronted with the awesome law enforcement machinery possessed by the state. New York State's right to counsel attaches earlier than the federal right. That is, as soon as a defendant is in custody, requests counsel, or once the criminal proceedings commence. The former circumstance does not create a right to counsel in the federal system, and although the right attaches upon commencement of formal criminal proceedings in both the federal and the state systems, New York State courts interpret commencement to occur earlier. But what makes New York's right indelible is that once it does attach, the defendant in custody may not waive the right to counsel in the absence of a lawyer. The federal standard, on the other hand, allows a defendant to waive that right outside the presence of counsel. The bounds of New York State's right to counsel have developed through state court constitutional interpretation, but settled through implicit approval by the people. If we recall that the framers of the original state constitutions, as well as the framers of the U.S. Constitution, believed in natural law, adopted the common law, and understood that legislatures had the power to alter it, and viewed the normative parts of those constitutions as statements of rights that largely operated to restrict governmental action, it takes little imagination to conclude that common law adjudication and state constitutional adjudication are cousins. One of New York's most distinctive deviations from federal constitutional law was created nearly 50 years ago in People v. DeBoer, which sets out a four-part test for warrantless police interactions with the public, as compared to the binary Terry rule derived from the Fourth Amendment. Even today, it is uncertain whether DeBoer is a state constitutional rule or a common law rule. In the federal system, that ambiguity might matter greatly, because if it is a constitutional rule, only the U.S. Supreme Court could alter it. In New York, by contrast, if DeBoer, no matter what its nature, outlives its purpose, or if a better rule comes along, or if it was a bad rule from the start, the Court of Appeals can change it, but so can the people. The knowledge that extrajudicial change is possible perhaps made it easier for the Court of Appeals to adopt the DeBoer rule, and easier to conclude that the court's legitimacy would not be badly tarnished, even had the people acted immediately to revoke it. The people of New York continue to provide our courts with opportunities to be visionary and, unlike the federal courts, to do so in the context of new, broad constitutional rights. In November 2021, 70% of New Yorkers voted to add environmental rights to the state constitution. Known as the Green Amendment, it provides that each person shall have a right to clean air and water and a healthful environment. Since the Green Amendment's passage, nearly 20 cases testing its application have been filed within New York State and the federal courts. Although none of those cases has yet reached the Court of Appeals, it is inevitable that a Green Amendment case one day will, and that those pioneering claims will call for innovative solutions and interpretation of that provision. The Green Amendment serves as another example of a well-functioning democracy permitting New Yorkers to establish a new, vaguely defined and potentially broad positive constitutional right, but the Green Amendment also reveals continued trust in the New York State courts to adapt and innovate the same way they have with other positive rights regularly added to our state constitution over the past 2 centuries, with the knowledge that the people can undo any judicial decision. I return to the question of legitimacy. The purpose of stare decisis is threefold: to promote the even-handed, predictable, and consistent development of legal principles, foster reliance on judicial decisions, and contribute to the actual and perceived integrity of the judicial process. Although the differences in state versus federal constitutional amendability may not weigh very differently into the first rationale, the difference in constitutional amendability certainly weighs into the final rationale for stare decisis, the legitimacy of the court. When constitutional change comes from only one body, as it does in the federal system, or indeed as it did with King George III, the overturning of a previous constitutional rule may appear as if it were done at the whim of the Supreme Court's justices, not because it necessarily is the law, whether law means natural law, original intent, or something else. The appearance of doctrinal instability inherently eats away at the public's view of judicial legitimacy, especially when the decision is out of step with current social needs or is perceived as politically motivated instead of resting on legal principles. By contrast, when the New York Court of Appeals, for example, interprets a provision of our Constitution in a way that is completely out of step with New York's needs, there is a reasonable chance that the Constitution will be amended. That reality also sets public expectations differently. Because amendments need not come from or be undone by the court itself, the court's legitimacy depends less on adherence to long-standing precedent than does that of the U.S. Supreme Court. Belief in omnipotence requires proof of perfection. Belief in a functioning majoritarian democracy requires proof of engagement. Peter Galley, a leading scholar on New York constitutional law and history, remarks that constitutional growth in a democratic pluralist order is likely to resemble a banyan tree, complex and baroque in character. A constitution is political in the fundamental sense that it is shaped by various forces present in the public arena, and as such is likely to take on the irregular and inconsistent contours that such a political order produces. In states where courts should feel less bound, in states where state courts should feel less bound by adherence to their prior decisions, the ramifying and expansive branches of that constitutional banyan tree successfully form. It is those branches that demonstrate the mutable nature of the democratic system the founders envisioned, because each new growth presents an instance in which the court, in conversation with the people, has transformed the Constitution. Understanding that state constitutional jurisprudence can be readily overridden places less emphasis on the courts, their adherence to stare decisis, and their infallibility. Although fallible, state courts are capable innovators and should participate without hesitation in the dynamic process of constitutional amendment in their states, secure in the knowledge that, in the end, the ultimate arbiter of the state's constitution's scope and sweep is the people. Thank you all very much.
I've sat through all of them. We have time for some questions or comments. Yes, could you identify yourself?
I'm Chet Kerr. I'm a NYU law graduate. I'm curious, as you think about the differences in the courts, you didn't mention, and maybe it doesn't come into play, but the difference between lifetime appointment in the Supreme Court versus appointment of judges in most state courts, and how that interplay of that difference impacts your thinking.
There's actually a footnote in what will be the article.
I'm sorry, I didn't read the footnote.
You know, yeah, I didn't read it. We would have been here till tomorrow. If I
Yes.
So I have a lot of thoughts about that, actually. It certainly does come into play. And one way I think about that is the following. If you think back to 1789, what was the life expectancy of a white man? Right? It wasn't 90. It was much less than that. So when the framers were thinking about life tenure, they were not thinking that somebody might be 40 years old and serve on the court for 50 years. They were expecting much more of a turnover. And that difference, I think, in the change in life expectancy has created a more stagnant, I think, system. I am actually a proponent of the 14-year term we have. I mean, whether it's 15 or 17 or 12, I don't think makes much of a difference. I feel completely insulated from any pressure to decide one way or another. My 14-year term is plenty long enough. And there's also some value, I think, in new people coming in. So, I think it does help state courts, I think, be more contemporary in their thinking, because you don't have people who are 80 years old who've been on the court for a very long time and are set in their ways.
Other questions? Comments? Carol, identify yourself, please.
Retired member of the New York Bar. I read from time to time about efforts to persuade the New York Court of Appeals to adopt a new constitutional right, and sometimes the decision is made, usually not unanimous, to say no. This is not something for the court, it's something for the legislature. And I'd be interested in your thoughts about how you and other members of the court make that decision and whether that divides along any ideological spectrum.
I don't think it divides along an ideological spectrum. I think if it at all divides, I think it divides along a idea of how active or not active a court ought to be. And that, I think you see that not just in our decisions about constitutional law, but common law as well. And I think that tends to be a function of what the composition of the court is at any particular moment. I think sometimes the court, when you think about the Cardozo court, quite active in adapting the common law. And that's, I think, not because of an ideological view, but rather a view of the role of a court. And, I think everything I said today exposes what I think. And I don't want to speak for anybody else.
Other comments or questions? In the rear there, would you identify yourself? Person whose hand was up.
Hi, I'm Nathaniel. I'm a former clerk of yours.
This is a real turnabout.
And now a member of our faculty.
So one thing that I was thinking about when you were talking, other than your wonderful words, was people often criticize the current Supreme Court for being political in the sense of justices giving speeches, writing, engaged in sort of a kind of movement politics. And I wonder if you have thoughts about whether there are whether there are or should be different understandings about how judges get involved in that kind of politics. I mean, in some states, judges are elected. In New York, we have an appropriately Byzantine merit selection system. But I wonder if you think that that has the sort of judge's role in politics outside of the courtroom is affected at all by being state or federal courts.
Well, Nathaniel, I think I would answer it this way. The judges in New York have a set of ethical rules and a commission that can remove them for violating the ethical rules that is independent, and another committee that can give them guidance when they have questions about that. And there are lots of advisory opinions and decisions about what a judge and when a judge can say something and what things a judge can't say. And I think that I, as chief judge and chief administrative judge Zayas, the advisory committee has given us a little bit more leeway in the kind of things we can say, but they really tend to be allowable around improvements to the law and not allowable around political issues. And the only thing I will add is something everybody knows, which is the Supreme Court does not have a set of ethical rules or anybody that can remove them other than Congress.
There in the middle. Your name?
Hi there, I'm Johnny Dock. I'm also a former clerk and former Connecticut state government.
This is a packed house. This is a packed house,
We're
Judge.
stacked with friendly questioners here. I'm also a former Connecticut state government official, so now that I know this might turn into an article, I have to note for the purposes of footnotes or otherwise that we proclaim ourselves the Constitution state on our license plate in Connecticut because of the 1638 fundamental orders, and those should not go overlooked. But my question is...
I feared that was coming.
My question is, the legislature and the people can overrule any constitutional interpretation of the courts, but as a matter of practical politics, they are in some cases more likely to do that in one direction than in another. It is difficult to imagine, for example, in the Article 11 case you brought up, the people banding together to offer the children of New York less than the court has said they should deserve. Should the court in its constitutional interpretations be cognizant of that political reality or blind to it?
I think it probably is cognizant of it when we were trying to operationalize a provision like the education article. You know, I think we could have said, and this is before I was on the court, of course, we could have said the state has to pay at least $100,000 for every child in the state for an education. I think if we had said that, we would have had an amendment. And so in that sense, I think the court is very cognizant when it has a case in front of it, and you have a broad, this is, I think, this same kind of conceptual thinking will come up when something like the Green Amendment or the Equal Rights Amendment comes up to us. We're going to be thinking, we always think about this, what are the actual real world consequences of this? And in articulating the right, we want to be careful. I think that then, if we're doing our job well, it isn't, I think, as you described, it's sort of that it's one-sided. It's that we're, if you want to say it, I guess, a little conservative when articulating a new right, and that is what I think creates the absence of an impetus to undo it.
Miss? You? Bring.
Not a law clerk.
No, not a law clerk.
Could you identify yourself, please?
Hi. My name is Denise Corsi. I'm an appellate public defender with Appellate Advocates. Hello, all your honors. When in my limited spare time, I do work on reproductive rights. And when I talk to lay people in that capacity, I often tell them that my favorite amendment is the 9th, the one about unenumerated rights, and the equivalent in New York. And my question to you, Judge Wilson, is whether you think litigants exploit those the New York version of that amendment enough, whether they should do it more, or whether there are limitations to exploiting that amendment or that right within the New York State Constitution.
That actually sounds like a question that the ethical rules won't let me allow to answer. I can say I'm glad you pointed it out.
Anyone else? Sir?
Hi, Martin Sawyer, also an appellate public defender. You've mentioned, or you talked about that in your position on the Court of Appeals, you have a certain, I guess, license or liberty to interpret constitutional amendments. in new ways. I wondered if you thought that that also possibly extended to lower courts when addressing constitutional issues that may not be, that you may not have done on the Court of Appeals yet.
So yes and no. So if there is a binding decision on a lower court, they're sort of stuck with it. But I think your question is really more directed to suppose when, let's say, a Green Amendment or Equal Rights Amendment issue comes up in a state court of first instance. Yes, of course they have to try and articulate that and reach a decision and operationalize it and put some rules around it if they can, which they have to. So yes, and I would encourage them to, in that sort of circumstance, I don't think they're thinking about it any differently than we are. They have less time and fewer resources, and we have fewer resources than Judge Sullivan.
Sir.
Larry Mandlicker, country lawyer trying to make my way in the big city. So given the difficulty in amending the federal Constitution, you listen to United States Supreme Court arguments and colloquy among the judges. You're dealing with strict construction, you're dealing with living Constitution, and you're dealing with limiting principles. Do you have the same issues in the Court of Appeals when dealing with a constitutional issue because the state constitution is relatively more easy to amend?
Well, I think my whole point is that we should not have the same, those considerations shouldn't get the same weight. I don't think they deserve the same weight. As I said, I think if you really went back and thought about what the drafters of the federal Constitution were expecting, I don't think they were expecting that the Supreme Court would functionally be the only way to change a constitutional doctrine. But that's where we are.
One more from this side. I've been favoring the right side. Anyone? Okay. Please. Would you raise your hand again?
Hi there, Alec Webley, also former law clerk. One of the interesting characteristics of the Court of Appeals' last few years of constitutional interpretation has been another side of the easy to amend, which is that the New York Constitution has a large accretion of content that, sometimes my favorite bit is where it starts talking about the freedom of assembly and then breaks off mid-sentence and starts talking about parimutuel horse betting. And so how the court says, okay, well, we use statutory interpretation concepts. One statutory interpretation concept that's never used in constitutional adjudication is things like the absurdity doctrine or situations where you have mutually inconsistent provisions. And I was wondering, how do you find those doctrines sort of at work connecting to what you've described about the ease of amendment?
Well, sometimes the remnants are just that, and you don't pay a whole lot of attention to them. But sometimes parimutuel horse racing provision or language in there actually came into play in a case we had that didn't involve horse racing, although we did have a case about horse racing as well. But that was sort of tracing its history, was interesting to understand the prohibition in the New York State Constitution about gambling. Because it turned out that the first form of gambling that was allowed was parimutuel horse racing, which had been invented in France and was the rage there, and people wanted to have it here, but there was the prohibition against gambling, and they needed to have a special constitutional carve-out for it. So you do look at even those provisions that aren't, that are now maybe surplus. And I guess I should also say, in terms of surplusage, there's plenty of surpluses in the federal Constitution. I mean, the 3/5 clause is still there.
Just on this question, do you think it's a good idea for there to be like a law revision commission to identify problems with the state constitution of that sort?
So I think it would be great to have a convention.
Well, this could be a preparatory work to a convention.
Absolutely. It's been a long time. And I think Alec would really like to be on that
Well,
preparatory commission.
my boss, Allison Shafini, who's just about Allison Shafini, by the way, is responsible for the success of all of our IJA programs. Allison says we break up now, and we thank the Chief Judge for this terrific set of remarks.